Hello, I'm Jessica Mills, and I'm here today with lawyer Penny Robertson, the manager of the LIV's costing service, to answer the 3 most common practitioner questions about costs under uniform law. The first most commonly asked question is, are there any changes under the new legal profession uniform law in relation to the charging of interest?
Yes, there is. The old law and the new law both allow you to charge interest at the cash target rate plus 2%. This is in the rules for the new Act under Rule 75. If you're going to charge interest, you have to put it on your bill when you send it out, both under the old Act and the new Act, and you must state that it's a cash target rate and 2%. Under the old Act, it was the date from which the bill was given. Under the new Act, it's the date from which the bill was issued. Whether that makes a great difference or not, we don't know, but it's necessary for you to keep a really close time calculation for the 30 days from the date you issued the bill. You may not charge any interest on any bill unless you give a notification when you send the lump sum bill. The really interesting change though, Jessica, is that if you don't send your account within 6 months of the completion of your work, whether you mention interest or not, you may no longer charge it. So that's a real incentive for lawyers to have a look at their file, keep an eye on their file, and make sure accounts are promptly sent to clients and that they promptly keep track of the 30 days.
Okay, and does the new uniform law deal with the position of when costs claimed in requested detailed bill are more than the costs claimed in the lump bill sum provided earlier to the client?
Yes, it does. In the old Act, if you had a lump sum bill sent out to your client, and as most practitioners will know, that's a paragraph or so discussing what you've done with the amount of your costs at the end. If you sent one of those out and then the client requested a detailed bill, which you had to provide within the required time, the detailed bill may come to a lot more than the lump sum bill, because you're going through the bill much more carefully and you're adding in a whole lot of things that you may have not seen before because you were doing it less carefully, perhaps, shall we say. You couldn't claim back the larger amount in the detailed bill unless the client decided to challenge your detailed bill in the costs court, and then the detailed bill itself was taxed, and whatever it came to was what the costs were, regardless of what the amount was in the lump sum bill. In the new Act, if you send out your lump sum bill for $10, for example, and then they request a detailed bill within the required time, the detailed bill comes to $14, unless you have put a notification on the lump sum bill, that's the $10 bill when you send it out, saying that if they challenge it and the detailed bill is more, you have the right to rely on the increased amount in the detailed bill. Without that notification, you are absolutely caught to the amount in the $10 bill. So it's incumbent on every lawyer when they send out their lump sum bill to put the wording on. If you have a look at the new Act and the rules, it will talk about the form of notification you must put on your bill, but you will not be able to have your increased costs if you do not put that notification on.
Okay, and my last question is, when costs are regarded as unfair or unreasonable, who is responsible and what happens?
In the old bill, if your costs were regarded at taxation as grossly excessive, and they were the words used, grossly excessive, then you were probably sent off to the Legal Services Commission to talk about why your costs were so high. Under the new Act, that's no longer the standard. The standard is, are they fair and reasonable? As you'll appreciate, that's a lower standard than grossly excessive. If you are deemed to have charged unfair and unreasonable costs, the taxing officer must report you to the Legal Services Commissioner, and the Commissioner may exercise his discretion to discipline you. And who gets disciplined? Well, under the new Act, the partner responsible for the bill and the practitioner who drew the bill. So that's a bit broader than it used to be. And what happens if nobody signed the bill? If you're the senior partner and the junior lawyer has sent out the bill and you haven't seen it and you don't know what's in it, the new Act deems you under Section 188 to be responsible for the content of that bill. So all lawyers should carefully now check what is in the bill, even if you didn't personally run the file, and make sure the costs there are what you would call fair and reasonable. Because if only 15% comes off, you're already looking at a bit of difficulty. So there really is a huge change in that area, Jessica.
Okay, and just finally, if members need assistance with costing, what should they do?
Well, we run the Legal Services Costing Service, as you have mentioned before. We also have a free advice line for initial advice. If it becomes very complicated, then we have to look at how we'll deal with it. But initial advice, when you're worried about costs, you're free to ring us up and we'll have a discussion with you about your problem and how we can give you some direction as to what to do with it.
Thank you for your time, Penny.
My pleasure, Jessica.